persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7141 et al. Samuel Shanks, appellant, versus International Union of Bricklayers and Allied Craft Workers. Ms. Mansbach, amicus curiae for the appellant. Ms. Coleman, amicus curiae in support of the appellant. Ms. Keller for the appellate.
Good morning, Mansbach. You may proceed when you're ready.
Good morning, and may it please the court, Alexandra Mansbach, court-appointed amicus on behalf of appellants who are here in the courtroom today. I'd like to reserve 2 minutes for rebuttal. This case concerns a two-tiered COVID vaccine policy that gave most of BAC's Black employees only 4 days to receive their first shot of the vaccine, while most white employees were given 76 days and better information for the same procedure. Combined with the increased level of vaccine hesitancy among Black Americans, BAC's policy resulted in Black employees being suspended or terminated at a rate 7 times higher than white employees. This is more than sufficient to state a plausible claim of disparate impact to survive our motion to dismiss for 2 main reasons. First, BAC cannot avoid disparate impact liability by claiming that all of its employees had the same opportunity to meet the vaccine requirement, both because employee choice is not part of the causation analysis and because the complaints allege that BAC did not give most of its Black employees the same time and resources to comply. Second, even though BAC was not a large employer and therefore the absolute numbers are relatively small here, the facts alleged are nevertheless adequate for a complaint. Whether the outsized impact on Black employees was correlated with race or just due to chance is a question for summary judgment after further factual development.
So you've emphasized that there were this 2-track policy, but your disparate impact claim would be exactly the same if it were just they announced a vaccination requirement and it happened to disproportionately impact Black employees, right?
Yes, Your Honor. But the fact that there was this 2-track policy bolsters the claim that there was a disparate impact here. We think that the statistics are sufficient to show that there was a disproportionate impact, but in some cases where the statistics may be insufficient to show statistical significance, courts have looked to other indicia to bolster their confidence that the effect was due to race rather than chance. So if the court thinks that this is insufficient statistics on a motion to dismiss, the other indicia, like the 2-tiered system, can bolster the confidence.
I'm not sure I follow the calculation of 4 days versus 76 days. First, the 4 days, what does that refer to? I mean, they announced a policy, and I believe it was August, having sort of presaged it for some months before that. And then the requirement didn't come into play until October.
Yeah, so what they required was that employees be fully vaccinated by October 4th, and full vaccination requires not just multiple doses of the shot, which have to be spaced a certain number of weeks apart, but also time for your body to produce the sufficient antibodies to be considered vaccinated, which takes place after the last shot. So to be fully vaccinated for Moderna, with the Moderna vaccine by October 4th, you would have had to have the first shot on August 23rd, which was 4 days after they announced this policy on August 19th.
And in terms of the 2 tracks, I'm not sure that I follow that. As I understood it, the policy announced in, I believe it was June, was anybody who's traveling is going to have to be vaccinated before they travel.
Correct.
And that would apply, it seems to me, it doesn't necessarily give you 76 days of lead time. Let's say it was June and I were an employee who had travel obligations. Those obligations could be 1 week later, 2 weeks later, 1 month later. I could think, I mean, employee who has some travel obligations but maybe no travel is scheduled for me. So I wouldn't think that I was under a particular deadline. And then some travel obligation arises, and whatever the lead time is in advance, once I know that I have a travel obligation 2 weeks in advance, a month in advance, 4 days in advance, I have to scramble. So I don't see this sort of where you get this idea of a unitary, those eligible for travel versus the rest of the employees.
So appellants have alleged that the first work travel was October 2nd. So there was no one who was obligated to travel for work before October 2nd. So there is no case of someone needing to be vaccinated in July and August. Second.
And where's that alleged, and was that known in June when that announcement was made?
It's alleged at JA 71, which is the chart that they break down. They say that the first work travel was October 2nd. It's, I think, the first footnote on that chart. It is possible that some employees may have traveled later, but all of the traveling employees knew in June that they would be subject to this vaccination mandate, and they could begin talking to their healthcare providers, talking to their religious leaders if they wanted an exception, talking to their families, thinking it through. They could begin the process to make this decision. And all the traveling employees were invited to the vaccine hesitancy webinar with the head of the NIH. So they had these additional resources.
Where's that alleged? Because when I looked at that webinar announcement, it seemed like it was directed at a different group of employees. It was directed at the employer council, which is not the same as the travel eligible employees.
So on JA 45, 171, and JA 65, appellants allege that that all the traveling employees were invited to the webinar, and the non-traveling employees were not invited nor told of its existence.
But the allegation refers to the document describing that webinar, which I think is on JA 62, which is directed at the International Council of Employers. And the framing of this community core event is about, is saying to potential employers of BAC members, here's something that you can learn about to make when you're employing our people to help them make informed decisions. So I'm not sure that I see any support for the idea that this was aimed in some disparate way, or that subset of employees were invited and another subset weren't.
So on JA 45 and JA 171 and JA 65, there are allegations that the traveling employees were invited to this webinar.
I saw that, but I also thought, and I was pointing to JA 45 where it cites, I think, this very document. It just seems like it's in conflict with it.
Well, I believe, I'm not sure exactly the content of the webinar, but the appellants have alleged that this was the webinar and that BAC did invite traveling employees to this webinar and did not invite non-traveling employees. And even later, after this webinar had been recorded, BAC sent this webinar to its members, its Bricklayer union members, could have sent it around to all of its employees who were also subject now to the vaccine mandate in August, but they did not do so.
And the reason that matters for your theory is what?
It matters for two reasons, Your Honor. One is that it helps to bolster the argument for why we would expect that the statistical disparity we see here is caused by race and not caused by chance, because there were more Black employees in the non-traveling group, we can say, okay, we see this disparity here, 13.5% of Black employees were suspended or terminated, but only 2% of white employees. If before we get to summary judgment and we have actual analysis of statistical significance, we can feel confident that, or at least it's plausible, that that effect was correlated with race, because we know that Black employees were given less time and less resources as a whole.
It's the less resources that I wanted you to be more concrete about. So is the notion that if this webinar had been shared among all staff when it was emailed around to the BAC members, the notion is that that could have addressed vaccine hesitancy. And so it's part of the disparate impact. It's part of the policy that is causing disparate impact?
Your Honor, I think Judge Garcia is correct that we don't necessarily need that to have a plausible case of disparate impact here, but it does bolster the case. It's not just the webinar. It's also the fact that for the June policy, there was slides circulated, there was an all-company meeting. None of those things happened for the August policy. So the non-traveling employees were left with questions about the policy, questions about vaccination, and there was no resources provided to answer those questions, even though BAC had access to those resources through the COVID community court.
And the idea is that those resources could have reduced vaccine hesitancy.
Yes, Your Honor.
But if someone has an underlying medical condition that they think would interact with the vaccine, that's distinct from vaccine hesitancy.
Correct, Your Honor, but the non-traveling group also had less time to submit exemption requests. They had about 3 weeks to submit medical exemption requests, and appellants have alleged that it was very difficult to get medical appointments at this time because of the height of the pandemic, so that they were unable to get medical appointments to get an exemption if they wanted. And it's not just for the exemption. They had less time they only had 4 days to get a medical appointment to speak with their doctor about their concerns of the vaccine, whether or not they were strictly medically related or they were vaccine hesitancy more generally.
One of BAC's main arguments on the disparate impact claim is that because there was an element of individual choice, this should be, there's a lack of causation. It's not in a genuine sense caused by the policy, but by, in individual choice. What is your response to that argument?
Courts have recognized disparate impact liability in many cases where there's an element of choice. For instance, the Supreme Court found that disparate impact liability could lie in a case that turned on methadone use, which is also a medical choice within the plaintiff's control. There's dress code cases that also turn on choice.
I really appreciate all of that. I guess I wonder, just as an analytical matter, at some point, is there a point where the voluntariness comes in terms of causation? So if this really were truly either get vaccinated or send us an email opting out. I appreciate that's not this case, but I want to know how to think about the legal framework. And it seems like in some way that ought to be a defense. And I don't know where that exactly comes into the analysis.
Yeah, I think you can't dismiss vaccine hesitancy as just willingness when it's kind of grounded in historical racial trauma and fears about bodily autonomy. I think in some cases, if there's a straightforward, evenly applied, patently justified, with no feasible alternatives, that maybe is enough that can be dismissed at the motion to dismiss stage. But here...
But maybe that would be because there's such an obvious business justification, something like that.
Right.
Not for causation.
Yes. And the causation inquiry is really looking at whether some specific policy of the employer caused the disparate impact to avoid bottom line liability. You can't just say, oh, okay, 80% of your workforce is white and 20% is Black. That's a disparate impact claim. You have to point to the actual policy, like refusing to recruit at historically Black colleges and university that resulted in that actual outcome. So the root of causation is really to make sure that you're pointing to something specific that the employer has done rather than just the bottom line result.
And so what is the policy that is being challenged here?
The policy that's being challenged here is the vaccine requirement that everyone be vaccinated by October 4th or submit an exemption by September 13th, about which some employees were told only a few days in advance and some employees were told months in advance.
And is it part of the allegations that in June, the travel eligible employees knew that they weren't traveling until October? That was not how I understood the record.
I believe that traveling employees would have known had they had imminent travel coming up, but the fact remains that in practice, they did have at least 76 days to make this decision, and they were still on notice 2.5 months before the non-traveling employees that they were going to have to do this. In fact, when someone asked BAC General Counsel, hey, are non-traveling employees going to need to be vaccinated? She said no.
She didn't say no. She said we don't have a plan for that at this time. Isn't that right?
I
mean, I just read what's alleged.
She said, I believe she said no, they will not need that. There's 3 allegations about what exactly that she said, and one of them says that she said, no, you do not have to be vaccinated right now. Of course, that doesn't mean that you have to, that they could have never adopted a vaccination policy for the rest of their employees. It just means that when they did adopt one, it could have been more flexible on timing. They could have, the bargaining unit asked BAC repeatedly if they could extend the exemption deadline, and BAC kept moving that meeting until the exemption deadline had passed and then said, no, it's too late, the exemption deadline had passed.
And you said you had 3 sites on the non-traveling employees being assured that they were not
Yes, they're
subjected to a vaccine requirement.
JA 45, JA 65, and JA 157.
Right, thank you. So the Bricklayers posed the following hypothetical in its brief. An employer requires employees to report to work at a particular time. A group of employees are disciplined after they choose not to adhere to the rule, maybe citing, I don't know, would that state a claim if the group of employees who choose not to report are disproportionately in a protected class?
Would that state a claim? Yes, Your Honor. That doesn't mean that there's actually Title VII liability here. All that they're saying is that there's a disproportionate impact on some protected class. And if you, the concern with analyzing whether employees are just picking and choosing what to comply with is it's a very difficult line drawing exercise to make a judgment, especially on no record, about what's kind of a freely made choice and which kind of choices interact with societal barriers. So if you had an employer who said all employees must wear dresses to work regardless of gender, you can imagine that that would make male employees more uncomfortable and they might be less likely to comply. But that's still a choice. So it's a difficult question of where exactly is the freeness or the easiness of the choice coming in. In Griggs, the employees could have gotten high school diplomas. They did not, probably because of societal and economic factors that were outside of their control, but it was still a choice.
So in the Bricklayers hypothetical, if the late employees challenge the report to work hour, saying we are primary caregivers of kids, and it's harder for us to get going in the morning. Your report to work time has a and caregivers are still disproportionately women, so it has a disproportionate adverse impact based on sex. That would be a clearly state a disparate impact claim in your view.
Yes, it would.
And it would have to go to discovery, and then the employer would be able to proffer a business necessity justification.
That's right, Your Honor. I think that the goal of disparate impact is to avoid policies that unnecessarily create a headwind for certain minority groups. And at the motion to dismiss stage, you're just looking at the headwind. Did this make it harder in some ways for minority groups? And at later stages of the case, you're looking at, well, was this necessary or not? Right? There might be very good reasons why everyone needs to be at work at 8 a.m. And that could very likely mean that the employer wins, but it doesn't mean that they have not shown that there's some disproportionate impact on women of this rule.
Mm-hmm.
We've talked so far, at least explicitly, about the disparate impact claim, and on the disparate treatment claim, it's obviously one thing to raise concerns about the process and the timing. Something entirely different to say they were actually motivated by an intent, even in part, to, I guess, punish single out Black employees when there's fairly obvious alternative explanation, which is they wanted all their employees to get vaccinated. And I just wonder, beyond sort of process anomalies, maybe that's all you have, but where's the ingredient, the hint that racial animus was underlying this?
Yeah, two answers, Your Honor. First, it's not that they implemented a vaccine mandate. We all understand what was going on in the world at the time. It's that they implemented this specific requirement that only gave 4 days to certain groups, that they were completely rigid on the timing, especially knowing the racial composition of the two groups and the background vaccine hesitancy. There's also the entire context here. There's the alleged history of discrimination at BAC, and there's the fact that the goal of the vaccine requirement was for full-time return to work in October of 2021. At least 2 years later, they still had not fully returned to work, even though 3 Black employees had been fired for failing to get vaccinated in time for full-time return to work.
I'm not sure I followed, like, in terms of exposure in the workplace, full-time return to work versus part-time. If you're going to be in an office where other people are also required to be present, just to help me out with the distinction between whether you're there 3 days or 5 days.
So before the October 4th deadline, BAC had a hybrid model of work where some work was remote, some people maybe were in some days, and the reason that they were pushing allegedly the October 4th deadline was because of full-time return to work, but they had not full-time return to work. Also, the fact that they were hybrid meant that remote working was still an option, which could have been an accommodation, or at least could have let the non-traveling group have longer to be vaccinated while they did remote work in the meantime. Or if they only had to come in the office some days a week, they could have done testing on those days. Testing was an option that the DC government used as an exemption in its vaccine mandate. So there were many other things that BAC could have done.
And there's no, I take it your response to the failure of the plaintiffs to make any effort to submit an accommodation request, even incomplete, saying, I need an accommodation. I have, for example, in Mr. Shanks' case, I have an underlying medical condition that I'm concerned might be adversely affected by this vaccine. I'm unable to get a medical appointment right now, but I'm diligently trying to do that. There's no evidence that any of the affected employees sought to do that, but your position is that that's not at all required.
Correct, Your Honor. And Ms. Lambert had drafted a religious exemption request, but in the past, she had concerns with a particular employee at BAC. And in the past, when Ms. Lambert had submitted what she thought was essentially evidence and supporting documents to her point of view. This employee at BAC refused to look at them, called her a liar, other issues. So Ms. Lambert was convinced that because the same employee was the one reviewing the exemption requests, that without a letter from her pastor, which she was unable to get in time, that there was no point, essentially. I don't think she was thinking about preserving her legal rights. She thought that there was no point in submitting this to this person without supporting documentation. Further, what they were supposed to do in grievances with management is go through their own union, the bargaining unit, and the bargaining unit was working really hard to extend the deadline for exemption requests or for vaccination, which BAC refused to do both.
And there's no allegation that the union or that the non-traveling employees were asking for more education or vaccine hesitancy resources. I saw that they were asking for more time and actually were successful in part in getting more time and then an extra grace period. But they weren't really focusing on information in the lead up to this deadline.
They didn't know about it. Even the assistant HR manager didn't know that this vaccine webinar was a resource. Also, although there was a grace period, it wasn't announced until October 1st, and it only extended 2 extra weeks. So unless you had already begun the vaccination process before October 1st, the grace period wouldn't have helped you. See, I'm over time. No further questions. Thank you.
Okay. You?
Good morning, Your Honors. May it please the Court, Gail Coleman for the Equal Employment Opportunity Commission. The focus in a disparate impact case is on the effect of an employment policy. The statute describes employment policies or practices that cause a disparate impact on the basis of race. Briggs in the Supreme Court described that as meaning a practice that is fair in form but discriminatory in operation. Here, Judge Garcia, you asked for the disparate impact claim. Would it make a difference if the employees were challenging it just as a straight vaccine mandate, or if they were challenging it with the mandate together with the two-tiered rollout in terms of the causation analysis? And the answer is yes, it does make a difference for causation. Here at page 189 of the joint appendix, Lambert alleged if BAC would have given equal time and resources, the 3 Black employees would not have been terminated. And that is the core of the claim here. So that down the road, when it gets into causation, to discovery, down the road after the motion to dismiss and they succeed, if it turns out that these individual employees would never have gotten vaccinated, no matter how much time they had, no matter what information about vaccine hesitancy, nothing could have changed their minds, then it wasn't on BAC, on BAC, that there was a disparate impact. And BAC would not be held liable for something it hadn't caused. If that were a different...
Why is that? How does that fit with the other? I'm not sure it fits with how plaintiff is presenting. The amicus is because the point would be, even in the abstract, if you had a vaccine mandate, nothing else to it, and it turned out 100 Black employees didn't comply and were fired, and 0 white employees did, then wouldn't that state a disparate impact claim?
At the motion to dismiss stage, yes, it would. Okay. Down the road in discovery, it would make a difference only if you're only going to hold an employer liable for something an employer is responsible for causing. So if it would have made no difference to any given employee whether they had more time or whether they had more information, then the fact
there was no vaccine mandate in my hypothetical, that's not this case. If there was no vaccine mandate, the employees
exactly right. That employee still could state a claim. Here, where the allegation is it was the lack of time and the lack of information. Causation is a little bit of a different analysis. So
I'm sorry, I didn't mean to interrupt you. I'm a little, so the accommodation is if you had a medical condition, an underlying medical condition, and you wanted an accommodation because of the potential interaction with the vaccine, and there's no reason to think that the African-American employees were more likely to have those medical conditions. It seems like that's distinct from vaccine hesitancy. I think Ms. Lambert very succinctly expresses a version of vaccine hesitancy when she says, I'm not going to have something put in my body that's been invented within the last year. Do you see that distinction between those two barriers? One is an individual's desire to consult with a doctor because of underlying medical conditions versus a sort of historical and racially correlated mistrust of a medical system that has, as Ms. Lambert points out, in the Tuskegee experiments and other situations, really failed to equally value and understand the health needs of African Americans.
the focus here should always be on whether the employer is plausibly responsible for a disparity. And again, we are at a motion to dismiss stage. So under Iqbal and Twombly, you were looking only for plausibility and looking at the facts in the light most favorable to the plaintiffs and making all reasonable inferences in their favor. But doing that, looking at the facts in the light most favorable to them, here the allegation is that if Black employees had had more time in which to obtain an appointment with a medical professional to discuss their concerns, they could have timely submitted an exemption request, a medical exemption request. So the element of choice, it's not about did they have a choice and what was the basis of the choice. The question is, did the employer interfere with their decision-making process in making that choice? And here, the employer allegedly interfered by giving most Black employees less time than most white employees, making it harder for them to discuss their healthcare concerns with a medical professional, making it harder for them to decide whether or not to get vaccinated. So the causation analysis is not about, is there something connected to race in the employee's head? The causation analysis is about, is there something about the employer's policy that affected the choice?
Seems like it's a different aspect of the policy potentially. One might be more time for accommodation. The other might be just more time to learn about the safety of vaccines in general.
That's correct.
Those seem factually.
That's correct. But
So I'm sure the commission has thought a lot, long and hard about the difficult question at the core of this case, which is, in the summer of 2021, even though the management person said she didn't foresee a need for a general vaccine policy, within a month, there was the Delta variant spiking, and there were really a lot of morbidity and mortality coming from that. So you're an employer and you want to keep your employees safe. So being pretty loosey-goosey about timing is in conflict with that. And I take it your view is, well, that has to go to discovery and summary judgment.
the EEOC is here because what you rule in this case will affect not just COVID vaccination cases, but will affect disparate impact cases across the board. And here, looking at the Iqbal-Twombly standard, there is enough to get past a motion to dismiss. That does not mean that BAC is ultimately going to lose this Title VII case. After discovery, they may be able to disprove the inference of causation. They may be able to prove a business necessity. They could win. what the EEOC's position is that right now, right here on a motion to dismiss, these plaintiffs have alleged enough to make it plausible that the employer's policy caused a disparate impact because of race. Looking at
May I
the
ask you
text
a
and the light.
Oops, sorry. Finish your answer, please.
No, I'm sorry, I couldn't see you sitting here, so.
No, please finish your answer.
Oh, I was going to say plausible because 30% of the workforce, BAC had 124 employees. 30% of them were Black. In the absence of discrimination, one would then expect that 30% of the people who are adversely affected or who are terminated would be Black. But as it turns out, 83% of those who were adversely affected were Black, and 100% of those who were terminated were Black. There are, as you've seen from the briefing, a lot of ways to think about these numbers, and statisticians could come at them in different ways with different tests, looking at different sample sizes and subsample sizes. Statisticians will differ. There are certainly tests that can be run on small sample sizes, and then there's a question about how strong is the inference, how weak is the inference. That is a question for a fact finder, looking at probably competing statistical reports and determining which is more credible and reliable. That's something that the Ninth Circuit just said in Frade. It's not a question for pro se plaintiffs as they're crafting a complaint. So from the numbers alone, it is plausible that a statistician could find a statistically significant disparate impact. And even if
could
not,
I ask you, counsel, a question?
Mhm.
In Iqbal, and that's the standard on which the plaintiffs are relying and you're arguing, do not a lot of our questions this morning go to another aspect of Iqbal? And I don't know how you want to define it, but it does talk about common sense. And as you know, presumably, from cases that have come before the commission, there was a medical crisis at the time in question. And people were dying. Hospitals were overwhelmed. And the vaccine finally comes out, and it's only available to certain groups, normally by age. And an employer, any employer, presumably, wants to protect his employees. It doesn't mean he can force feed them, but as an employer, he has a duty not to cause death or hospitalization of his employees, just turning it around. So how does the commission deal with that as distinct from a lot of these cases that are cited to us, which arose when the South had signs up that said, you know, whites only, no Blacks. So the environment was a different environment in which a lot of those cases were decided. Now we have a medical emergency. Do you make any distinction in terms of what Iqbal's talking about, in terms of plausibility and common sense? What does the court do with that?
well, the medical emergency certainly is going to be part of the employer's business necessity justification. In disparate impact, the fact that there aren't signs up like there used to be, intent is not an element of a disparate impact claim.
I'm not arguing that those legal arguments that you and the appellants are making. What I'm just asking is, what does the court do with the language in Iqbal, which certainly talks about plausibility, but the court discusses how you reach that determination?
Well,
And
I
that's
think
what a lot of our questions are going to.
I understand, I think, Your Honor, and I think that goes back to the causation analysis, and where we started, which is what is the claim in this case?
Yeah.
And if the claims were challenging just the existence of a vaccine mandate, period, I think that gets to exactly what you are speaking to. How could a vaccine mandate not be a business necessity in a climate where people are dying? And that is one thing to think about. This allegation here is more than that. And here the employer is going to have to show as a business necessity, not only people were dying, but it was important for us to do it, the rollout in this two-tiered way and to be inflexible on the timing and to not give the information to everybody. That is part of what would have to be defended in order for the employer to prevail on business necessity in this case.
Do we need, so I have sort of two related questions. Twombly and Iqbal do also invite courts to credit on the pleadings an obvious alternative explanation. How would you guide us to deal with that language here?
Well, I don't know on the pleadings, Your Honor, that there is an obvious alternative explanation for why when BAC finally did meet with the union on September 20th or whatever it was, they said, sorry, we can't waive or we will not extend the deadline for seeking an exemption because the deadline has already passed. There's no obvious explanation for why they couldn't have said, fine, take another 2 weeks. So I do think there are questions here for a fact finder. These are pro se complaints. This is a motion to dismiss. All we're looking for is plausibility. And the fact that a claim is plausible, again, does not mean the plaintiff is necessarily going to prevail. It very well may be in this case with the COVID mandate that the plaintiff won't, but that is not the question before the court now.
So what is the rule that you propose that we adopt? You talk about this having having implications for many cases.
Mm-hmm.
And if you could sort of, spell out with some applicability to this case, how you would decide it.
As the Supreme Court laid out pretty clearly in inclusive communities, in order to state a claim for disparate impact, a plaintiff has to show that there is a disparate impact, that there is a specific employment policy that they are challenging, and that the disparate impact is plausibly due to that explicit employment policy. That's all.
And to you, here, there was some back and forth about this at the outset of the questioning. The specific employment policy is what?
The specific employment policy here is the vaccine mandate coupled with its rollout, in which the majority of white employees were given more time than the majority of Black employees to comply with the policy. And also the majority of white employees were given more information directly combating vaccine hesitancy, even though as a group, the Black employees were more likely to need that specific information. All of it is tangled up as a package together as the policy that's being challenged.
And how would you articulate exactly what the causation question is? Because a very simple version of it would be, there was a mandate, and the causation question is just, were the employees fired because of that mandate?
No.
Or because of something else?
Because
More
the policy here is more than just the mandate. It incorporates the rollout. The causation question here would be, did this two-tiered rollout plausibly cause the disparate impact that we are seeing between Black employees and white employees in the compliance rate? Is it plausible?
And why is that? Why is it not just fired because of the mandate?
Because the policy being challenged is broader than that. And in the statute itself, section 2000, I think it's E2K, talks about employment policies or practices that are all tangled up together. They're so intertwined you have to look at the thing as a whole. And that's what this court did in Davis. You do have to look at all of it, which is why I said, if this were a different case, if we were only looking at there's a policy and now these people are fired and why, there's the causation analysis, they were fired because there's a policy. But in this case, we're saying there's a policy and it, in practice, applied to the Black employees differently than the white employees. And did that make a difference in what we saw with compliance rates?
Just seems a little odd that the fact that they have more factual allegations about a more specific, oddities in the process makes their causation showing. On your telling, it makes the causation burden harder.
It makes the causation burden harder, but then on the other end, it's going to make business necessity harder for BAC. Because if in fact it was the two-tiered rollout that caused the disparate impacts, then that is the piece that BAC is going to have to defend.
Another question is, in terms of, these are pro se plaintiffs, and although they've had able amicus and amicus from the commission, I assume they'll be on their own again in were the case to be remanded. Is there a streamlined way that a trial court and also the employer, as you've intimated, could very well have a, prevail ultimately? Could this be, the business necessity be served up through a motion on the pleadings, some kind of answer, and then considering that?
I don't know the answer to that. I mean, certainly there could be summary judgment on it. I'm sorry, I just don't know.
Following some discovery, presumably. Judge Rogers, any further questions?
No, but I think part of your response might have been, it's not only the mandate and the rollout, but in addition to Iqbal, at the motion to dismiss, this court, or any court, must look at the allegations in the light most favorable to the plaintiff.
Exactly. That's exactly right.
All right.
Thank you very much.
Thank you for your amicus participation. We'll hear now from the Bricklayers, represented by Ms. Keller.
Good morning. May it please the court. My name is Kathleen Keller, and I'm here representing the appellant defendant, the International Union of Bricklayers and Allied Craft Workers. The judges in the questioning this morning have identified some interesting and difficult questions around the margins of the disparate impact doctrine. But I'd submit that this case is not the appropriate case to try to delineate where the lines are on some of these difficult disparate impact questions. And that's because the plaintiff's claim here does not meet the Iqbal-Twombly standard under any light, and even reading the plaintiff's pleadings in the light most generous to them. The number of employees they claim to be affected here is not large enough to show the significant statistical disparity that's necessary for disparate impact claim, nor is the differential impact between the races significant enough to state a claim. Disparate impact, as the EEOC counsel stressed, it's different from disparate treatment claims because there's no need for the plaintiff to show any sort of discriminatory intent or animus. As a result, the courts have always held these claims to a higher standard and held that the effect on the affected group must be so stark as to equate to discriminatory intent. The statistics pled must be of a kind and degree sufficient to show that the practice in question has caused the exclusion of the employees because of their membership in the protected group. And the Supreme Court has stressed that it's not appropriate to hold a defendant liable for unintentional discrimination on the basis of less evidence is required to prove intentional discrimination. So let's turn and look at the numbers here. The Bricklayers on the pleadings here had about 124 employees at the time.
When you refer to the Supreme Court's statement about unfair to hold on the basis of less evidence, which case are you citing?
That's the Watson case, Your Honor. Of the approximately 124 employees that the Bricklayers had at the time, 37 were Black and approximately 52 were white. That's on the plaintiff's pleadings. And over 90% of the Black employees, 34 out of those 37, complied with the policy and were not terminated due to the policy. So we have an over 90% compliance rate, an over 90% pass rate, compared to, on their pleadings, 100% of the white employees. So again, looking back to the Watson test here, we're looking to see whether those are statistics of a kind and degree sufficient to show that the practice in question has caused the exclusion of the applicants because of their membership in a protected group. And here we have a very small differential, over 90% to 100%. And a small differential like that is particularly problematic where you have a small sample size. Because where the sample size is small, differences are much more likely to result from things like personal choice, random effect, or other variables, rather than be caused by the protected characteristic, which is here, race. I want to turn to the question which has occupied most of the questioning and the argument this morning, which is about whether the process by which the policy was adopted has a disparate impact. And the amici have characterized this as a sort of two-tiered rollout, which I think is a mischaracterization of the record, and also the wrong way to think about this case. The focus, I think, has been on the rollout, on the notion that in June there was this announcement that if you're going to be traveling, we'll need you to be vaccinated before you travel. And then in August, they made the announcement that all employees would need to be vaccinated. And I think the focus has been there largely because amici have realized that the policy itself that 90% of Black employees were able to comply with does not itself suffice to state a disparate impact claim. But even looking at what they characterize as a two-tiered rollout, that doesn't change the ultimate statistics that they've pled here. You still have a situation in which over 90% of Black employees were able to comply. And the timing is really, I think, a red herring. They've put
ask you, obviously, one way to look at it is 90% were able to comply. And they would say the way to look at it is 100% of the employees fired were Black. And that's a question, I assume, that would be resolved by statistical experts. And it seems like a small sample size to me, but I'm not an expert. And it just seems like the kind of question that would be resolved at summary judgment. How do we know that your way is the right way of looking at it? And how do we know that 3 versus 0 is too small?
And I think that gets back to what Judge Rogers alluded to with the Trumbull-Igby standard, asking the courts apply common sense and judicial experience. And here where you have such a small number, 3 out of 37, 3 out of 124 employees, then it's appropriate to look at what we call the pass rate versus the rejection rate. You could have a policy where 2 men were terminated and 1 woman. And somebody could say, oh, well, twice as many men were terminated under this policy compared to women. But the numbers are so small that applying typical judicial common sense, you can see that that argument is not of the type and degree that would be that would cause a plausible inference of discriminatory effect. And I posit that the numbers here are similar. Where you have only 3 out of 37 Black employees that were unable to comply with policy. I want to also focus on this timing issue. And Judge Puller had the question about how do they get to the 4 days. There's a couple different ways you can crunch the calendar on that. But essentially they had, if they were going to get the Pfizer shot, which was the only one with general approval in August of 2021. That would have been 11 days after the policy was rolled out in order to get the first shot. And then with the 2-week negotiated extension, that would have been pushed to 25 days. But significantly, in the plaintiff's pleadings, neither plaintiff has pled that they requested more time, that they raised an issue that they needed more time. What they have pled is that the bargaining unit met with the bricklayers and said, look, there are a couple employees that do need a little bit more time. And so the bricklayers with the staff union negotiated a 2-week extension. So there were a couple people for whom the timing was maybe an issue. And so that was resolved within the negotiations between the bricklayer and the staff union. And so therefore there was no one who was affected by the policy, meaning terminated by the policy, such as the plaintiffs here, for whom the timing was the real issue. And they have not pled anything that would plausibly suggest that it was the timing of the rollout that caused the issue
What
here.
about Ms. Lambert's, as I understand it, had an allegation about consulting with her pastor and didn't think she had enough time?
And the policy itself, if you look at the words of the policy, it says September 13th for accommodation requests absent extenuating circumstances. And certainly, within the words of the face of the policy, it says extenuating circumstances. So if someone had come and said, I really would like to speak with my pastor, but he's been on vacation and I haven't been able to reach him or her, could I have more time in order to do so? That would certainly have been extenuating circumstances. But there's absolutely no pleading that suggests that either of the plaintiffs did anything like that.
Where's the quotation to extenuating circumstances? I know it's in your brief.
It's in the policy itself, which is JA 9.
Yep.
Any such request should be submitted as soon as possible and absent extenuating circumstances no later than September 13.
So at the pleading stage, your analysis is that the allegations regarding the attempts by their representatives to get meetings or to get a meeting with a representative of the employer about an extension, that we must view that as not encompassing the plaintiffs themselves as needing an extension, even though we have at least one plaintiff who had something in writing and was thinking about it, but thought that she would be turned down if her request was submitted to a particular employee of the employer.
What was pled is that the staff union attempted to get a meeting before the September 13th deadline, and there were scheduling issues. But it's also pled that the staff union did, in fact, in that second half of September, meet with the bricklayers, and at that point raise certain particular unnamed individuals who were having some issues with the timing. And that is the point at which the 2-week grace period was negotiated, specifically to account for those people who had been brought to the attention of the bricklayers by the staff union.
I appreciate that. My question is, viewing the allegations most favorably to the plaintiffs, why is your analysis consistent with that?
Well, I'm operating on their pleadings and their allegations. And what they haven't planned.
Let me just, and you're probably more familiar than I, but I just want to be clear about this. As I understood it, they were trying to get a meeting, and had the meeting not been postponed several times, the meeting would have occurred before September 13th. Is that not correct?
That is what they've pled, Your Honor.
All
But
right.
what they have not pled is that at any point when they did have the meeting, that the staff union raised issues about Mr. Shanks or Ms. Lambert having timing issues. They've pled that the staff union raised issues about other individuals who specifically were trying to comply, wanted to comply, but needed some additional time. And a solution was negotiated for those individuals. But they have never pled that the staff union raised issues about their issues with the timing or attempts to comply, nor have they pled that they specifically went individually to the HR department or to anyone else at the Bricklayers to say, hey, look, we're trying to do this. We're trying to figure out what our religious situation is or our medical situation, and we just need a little bit more time. There's no allegation that they specifically did that. So the timing, I think it's really even taking their pleadings in the light most favorable to them and incorporating everything they've said in their briefs into their pleadings. It's plain that it did not make a difference for these two plaintiffs at least.
Well, one view would be that it would suffice if they had adequately pled that they would have or may have gotten vaccinated if they had more time. Sounds like you're saying they also need to show that they came to the company and told them they need more time. What's the basis for requiring that the second showing? Or do you agree that, right, if it was crystal clear, if I had had another month like the traveling employees, I would have at least had more time and likely would have gotten vaccinated, but I wasn't given that chance.
They're claiming that a specific policy and process had a disparate impact. And where they failed to plead that that these issues were raised in such a way that the Bricklayers could that it could affect the process, I think that's fatal for their process argument, at least.
Okay.
I wondered about two things that seem pretty critical to the plaintiffs as they frame the case. And the one is the webinar, the vaccine hesitancy webinar, and the other is the greater lead time. And on the webinar, I guess I sort of have two related questions. One is whether it was, maybe this is a question of how we read the pleadings, and here the district court read the pleadings with a lot of, very much in favor of the plaintiffs, but the Council of Employers was the target. Is it also the case that the travel eligible employees are sort of part of that group or were actually part of the audience for that? And how do we weed through that question is one. And then the other is the question about travel, and when it was announced in June, did everybody know that that was talking about travel only in October?
Yeah. Let me take those each in turn. So if you look at, and Your Honor, your questions earlier this morning, I think circled in on this. If you look at the face of the document announcing that webinar with Dr. Solondz, it's clear that this is an industry-sponsored event through ICE, the International Council of Employers of Bricklayers. And the intended audience of that is the individuals who negotiate the contracts that protect bricklayers working on masonry projects throughout North America. It specifically is, inviting local unions, contractors, people who are involved in negotiating those terms and conditions for bricklayers. If you think about, what the Bricklayers is and what it does, it has people throughout the country that are servicing those contracts and providing support for those local unions and those members that are working on masonry projects across the country and across North America, in fact. And on the facts pled, there's 14 field employees, for instance, that are included in that 124 employees who are spread out throughout the country working on those issues. So it's plain from the face of the document that that's who the audience is, and that's who would have been invited to the webinar. And
I guess I'm just confused why do we care so much about the face of the document? It's totally consistent to say there was a document that went out and invited one bucket, and BAC separately also invited all the traveling employees, but not the other employees.
Well, it makes sense for the face of the document that one would invite the employees that are working on those issues with the industry construction employers. And I think the fact that the plaintiffs have relied so heavily on this one webinar that was essentially designed for the Bricklayers sort of customer base, the members, the local unions, the people that are out there negotiating, along with its counterpart within the industry, the fact that they've relied so heavily on this is sort of an indication of the weakness of their case. The idea that an employer who does something to sort of educate its customer base about something, the fact that they did not invite 100% of their staff to sit in on a meeting like that, that itself cannot be
It seems like
evidence.
the ultimate allegation is that they invited or shared it with every single person they could imagine, other than the group of mostly Black employees, right? And
Membership,
I
it went out, it recorded, went out to membership.
And so, and this is also just one of many, many allegations. I guess one other important one I wanted to ask about is the assertion that you've got a very short timeline, and the message is we've got to get this done by October 4th. And then at least the allegation seems to be, but nothing changed. You were on hybrid work, you continue to be on hybrid work. Maybe at summary judgment, you can come in and say, well, actually, there was some other change after October 4th. But if the allegation is stated need is we're returning to full work on October 4th, and then that doesn't happen, isn't that the type of evidence you typically look for as at least a hint of pretext?
I think that argument might go to the business necessity, and I don't think we get there yet. But I also think that, again, applying common sense and judicial experience, much of the country for office workers has been on hybrid work for a period of some years now. And that doesn't mean that safety precautions for people that are working in the office aren't necessary. This policy was applied specifically to people that would be working in the office. And the fact that they may be working hybrid 1 day a week at home or 2 days a week at home, I don't think undercuts that. But I think that really gets to the business necessity, which is, I don't believe we're there yet. But it does perhaps put a finer point on why it's important and why the case law over 50 years of this jurisprudence has stressed that you don't get to that business necessity inquiry and the inquiry about whether there were alternative steps an employer could take unless the plaintiff has pled a statistical disparity that is stark enough to suggest a plausible inference of discrimination. And I don't think that's been done here. There was one thing on the travel that I did want to.
Before you say that, you did lead with the small number of employees, and I don't think we have a case in our circuit about a small number of employees being problematic in terms of showing disparate impact. Am I right about that?
That's right. I was somewhat surprised over, the more than 5 decades of disparate impact doctrine. There's very, very few cases that involve small numbers of employees. And the cases where you have small numbers like that have gone forward, there's usually some external factor, like, for instance, there's the Domino's Pizza case, Pizzico out of the 8th Circuit, where you had a small number of Black applicants for the position, but that's because the position required a clean-shaven face. And there were statistics pled that between 25 to 50% of Black males would be filtered out by a requirement of that sort, whereas less than 1% of white males would be filtered out by a requirement of that sort. So you can have a situation where there are small numbers and still state a claim where there is some sort of allegations of a larger statistical impact. Certainly if you had an employer that had a small number of positions that it was hiring for, but said that you had to be 5'10" to apply for it, that would, on its face, weed out the majority of women, and a claim could be stated there. I think that leads into the questions that the court had about vaccine hesitancy. And one thing that I want to stress here is that while the plaintiffs have pled a generalized vaccine hesitancy related to historical discrimination against African Americans in the medical field, what we're talking about here is not writ large a vaccine mandate, but we're talking about a requirement for a specific vaccination at a specific moment in time. And what they have not pled is specifically within that time period, so August, September of 2021, and specifically with respect to this vaccination, the COVID-19 vaccination in this applicable labor market, that there is a significant statistical disparity in access to that vaccination. I mean, I think if we were talking about February of 2021, it might be a different case, given that there were early on disparities in how vaccine access was playing out. But we're talking about August and September of 2021.
I didn't want to lose track. I had asked you a couple questions earlier, and I know I stacked them, but the question about the announcement for traveling employees to get vaccinated, when I first read that, I had thought that was not really effectively setting a single deadline because people's need for travel might vary. In fact, some of those people might face a much shorter deadline than the staff when the general vaccine mandate came in. Some might effectively have longer. Did the Bricklayers management know on June 7th that the first meeting requiring work travel would be in October?
I'm glad Your Honor asked that, because I think the briefs are somewhat misrepresent the facts as pled here. I'm looking at JA 71, and what's pled is the first BAC meeting that required travel was held in Chicago during the weekend of October 1st, 2021. And if you look also at JA 17, it makes clear that the meeting that's being referenced is the executive council meeting of the Bricklayers in October of that weekend. But there's no allegation that no one was traveling beforehand. And there's also no allegation as to whether these quote unquote traveling employees were required to go to the executive council meeting that weekend of October. So I think it could flip both ways, that there could be, and particularly given this is an international organization, they have 14 field employees that are out there working outside of DC. And they have contracts that they're servicing across North America. So it's certainly plausible to think that there are individuals in that supposed traveling employees category who are going to be traveling, who would like to be traveling well before October. And there may be people in that quote unquote traveling employees category who had no intention of traveling even to that October executive council meeting, because that wouldn't have been either something they wanted to do or something that they were required to do. And the pleadings on that are really sparse. All it is, the only allegation is that the first Bricklayer-sponsored meeting that would have required travel outside of DC was that Chicago Executive Council meeting on October 1st. So as Your Honor notes, I mean, this certainly there could have been people in that traveling category that had much less time because they would have wanted to travel perhaps in July, and they would have had to run out immediately to get the vaccine if they weren't already in process to get it.
Is there any, I don't think this is in the record, but one thing that the plaintiffs point out, I mean, everyone who was in the office throughout this period had to wear a mask. And one of the things that the plaintiffs were asking for is, look, when we're struggling to get documentation of a religious or a medical, confer with a doctor who's going to tell us we do or don't have basis for an accommodation, why can't we do test and mask? And is there anything in the record in response to that? Why couldn't they do test and mask?
There's nothing in the record that responds to that. And I think, again, this gets to the business necessity and whether there were alternatives, and the question of whether during the height of a Delta surge, a weekly testing option would have been sufficient to provide protection to employees. I do think that these vaccine cases are a little different from many other cases because it is not just about the personal choice that these plaintiffs made, but also about the safety for the other employees in the office. So the 34 Black employees who did choose to comply with the policy and get vaccinated in order to come into work safely, the 121 employees in the Bricklayers generally that complied with the policy so that they could come into work in as safe a way as possible.
What's your, as a litigator, understanding of if we were to remand this claim, what would you advise a judge to do to focus it efficiently? You know, again, we have, per se, plaintiffs and an employer that obviously doesn't want to spend a lot of time. What would you ask the judge to do in terms of structuring the disposition toward summary judgment?
Well, I
Could
think
it be done on a motion on the pleadings or not? Would there have to be some kind of?
It would, of course, depend on what this court would say on a remand and what would survive of the claims. I think at a minimum, we would need a repled complaint so that we even know what we're responding to, because at the moment, the complaint doesn't even contain the outlines of what their argument eventually turned into. But I do think it gets back to some of the difficult questions that were posited earlier about where the lines are with the endpoint, the rational endpoint for disparate impact. So it cannot be, I would submit, that anytime you have 3 employees who share a single demographic characteristic who decide that they aren't going to do something that their employer has asked them to do, that itself makes a disparate impact claim. You know, you can imagine an employer that requires everyone to attend sexual harassment training. And if you had 3 men that said, we don't want to attend sexual harassment training, that makes us uncomfortable, and we will not do it. Does the mere fact that it is 3 men who have been disciplined for refusing to do that state a disparate impact claim? I think the answer clearly has to be no. But somewhere between the test that the amici has posited and that test is the line. As I said at the outset, I don't think this case is a good vehicle for this court to figure out where that line is. It's a challenging question, I think, for the future of disparate impact. There clearly is a line someplace, but given the very sparse allegations here and the fact that there clearly was not a significant disparate impact on the Black employees, more than 90% were able to do so, and in fact may have been happy to do so, that I don't think this is the case for the court to test those limits.
You just mentioned a case and I couldn't catch the name. Is this the reference to the Pizzico case that you mentioned earlier?
Yes, that was just an example of a case. I think it's from the 8th Circuit.
Yeah, you said it's from 8th Circuit. Yeah. Okay. Just wanted to be sure I knew which case you were referring to.
All right. Anything else, Judge Rogers? All right. Thank you.
Thank you, Your Honors.
And Ms. Monsbach, we used up her time, but did she reserve?
Council reserved 2 minutes, but there was no time remaining.
All right, we'll give you the 2 minutes if you want it.
Thank you.
So the first thing that I'd like to address briefly is just the statistics. Eyeballing it and using intuition is just not enough to determine whether there is a statistically significant impact. In Jones, which was the First Circuit case involving hair used for a drug test, there was a false positive rate for Black test takers of 1% and a 0.2 false positive rate for white test takers. So that means, looking at it the way that BAC has, it was 99% versus 99.8%. But the court still found that there was statistical significance there because it was on summary judgment and there was expert evidence to analyze those numbers based on all the other statistics in the case and said there is statistical significance here. That's why all of the cases that BAC cites regarding small sample size, they're all on summary judgment or bench trial because it requires looking really carefully at the statistics because there's so many different ways to look at the same numbers in a case. Also, courts can bolster the statistical significance, especially in really small sample sizes, with other indicia that there may be a disparate impact on a particular group. So for instance, in Frade, which was about university professors' raises, the court looked at the statistics and also said, look, there are reasons here why we expect that female professors are going to be less likely to seek outside offers and therefore less likely to enter into retention raise negotiations. We have that indicia here, why we can expect that these statistics created a disparate impact. Second, even if there was just one policy and everyone had the same amount of time, if there was a disproportionate impact, that would be enough to state a claim. Disproportionate impact looks at whether there was an unnecessary headwind against a minority group, and the necessity part is the business justification and available alternatives that's looked at later. The headwind part for the motion to
I
dismiss
have one question though.
Yeah.
On the, do you dispute, right? That's what you just described is not this case. Seems as though the theory is that the policy is the vaccine mandate on an accelerated timeline. You dispute that that then changes the causation inquiry. They have to plead that all three of those fired employees at least plausibly would have been vaccinated if they had more time.
I think not, Your Honor, because even if this case just had the one requirement, everyone had the same amount of time, but they had pled this effect, you know, the 7% sevenfold difference in rates of effect, that would be enough. The fact, like if more people are.
Seems like it just seems, it's hard in this case, but it's very important what the theory of the policy is, because unless you disagree with the EEOC, it just completely changes what the causation showing is, and importantly, what the business necessity showing is.
Our position is that either way, appellants have stated a claim here. If you think that the policy is simply a vaccine mandate, they've still shown that this policy caused a disproportionate impact. The same way that a ban on renting to people with criminal convictions would cause a disproportionate impact on some races, as the Supreme Court has explained, or the Griggs policy. The policy caused a disproportionate impact. If you want to look more specifically at this specific timing aspect of the policy, I think that bolsters the case that, hey, we know that even if you think there's some element of choice that came into play here that makes this policy weird, well, Black employees did not face the same choice that white employees faced. Most Black employees had a harder choice in terms of compliance. And that's kind of where the timing comes in, but I think we don't need that. Either way, it's a plausible claim.
Say if it's just the vaccination requirement, if that's the only policy at issue, why is it that Black employees faced a harder choice?
You mean if everybody had the exact same time?
Yes.
Even if that was the case, they still faced a harder choice because of the background vaccine hesitancy that's been pled.
What if, is it wrong to read the causation? So there are 3 employees that were fired. One of them is not a party here, but both that other employee and Mr. Shanks, it wasn't really vaccine hesitancy. It was, I have an underlying medical condition. So then that leaves only Ms. Lambert, who said, this thing was just developed, you got to be kidding. And so you really have a one person who's the reason that she's not able to get the vaccine in time is because of vaccine hesitancy. But the other 2, it's much more personal specific.
So Mr. Shanks alleged that he had medical concerns and that he had vaccine hesitancy. He alleged both of those things. And there were 3 people that were fired, but there were 6 people actually, who were suspended or terminated overall. And we don't know what happened to those other people. Also, what we look at here is whether this policy had a disparate impact on a group. We don't necessarily, it could be that the white employee who was suspended maybe also had vaccine hesitancy. That's not what we're looking at. We're looking at, did this policy create a headwind for a certain minority group? If you think of the example of men wearing dresses, required to wear dresses to work, and maybe that some men are totally fine with it, doesn't make them uncomfortable. But it still means that as a whole, it would have been harder for men to comply with that rule.
Thank you. The case
Thank
is
you very
submitted.
much.
Case number 24-1105 et al. Michael Solondz petitioner versus Federal Aviation Administration. Mr. Nagy for the petitioner, Mr. Carver for the respondent.
Mr. Nagy, you may proceed when you're ready.
No, thank you, Your Honors. And I believe for 2 minutes for rebuttal, that's still permissible to reserve? All right, thank you. May it please the court. I'm Brandon Nagy on behalf of the petitioner and pilot, Michael Solondz, who's with us in the gallery in the front row today. Mr. Solondz is a rare example of a pilot who did everything right. In 2018, after the death of his father, he began experiencing severe anxiety. Rather than continue flying as a commercial airline pilot, he recognized the distractions and the difficulties the anxiety was causing, and he sought treatment and help. He self-grounded, reported his condition, took himself out of the air, and sought that help. Over the years, he tried a variety of antidepressants under the guidance of his personal doctors and the FAA's doctors, Dr. Levitt, and Dennison, two FAA HIM certified doctors, a psychiatrist and a forensic psychologist, and ultimately found that Rimron, the brand name of Maritzapan, was the antidepressant most effective for his particular genome and gave him the least side effects, the least negative effects, and frankly, cured and resolved his depression. After that, after more than a year of self-grounding, after multiple evaluations, including by the FAA doctors, which he was required to pay for himself, and it doesn't create a doctor-patient confidentiality, these are the FAA's experts, they gave him a clean bill of health, and both Dr. Dennison and Levitt agreed and recommended that he could continue pursuing fly to be ungrounded. So he sought that. He approached the FAA and asked for his medical clearance back. Well, the FAA, proving no good deed, doing the right thing, doesn't go unpunished, said no. They have said no for 4 years, and only after this appeal was filed in April did the FAA finally issue what they characterized as the air surgeon denial, finally explaining it's because you're on Rimron, period. They don't use the word blacklist, but they say it's unapproved, it's disapproved, and as they've been saying for 4 years, if you want a chance at flying again, get off Rimron. The advice and diagnoses and treatment and clinical records you've produced over 4 years be damned. None of that matters because you're on Rimron. Now, the air surgeon in its denial has explained why that is. Is it because Mr. Solondz has some sedative or a sleepiness, a drowsiness, a somnolence side effect? No. It is because the air surgeon has said, well, certain general studies show that some patients taking Rimron have that side effect. And they cited to one general study with 54% of patients exhibiting that side effect. Yet in the very next line of the denial, the air surgeon notes, oh, but by the way, on the high dosage, the dosage Mr. Solondz is on, only 14% of patients report that compared to 10% placebo. I know we were talking a lot about statistics in the last argument, and here, I don't think the court needs to delve into them as completely, except to say that rather than look at Mr. Solondz's pertinent medical records and the conclusions of the FAA's own certified and directed to trained physicians, the FAA has simply said, sorry, that's it. Get off the one medication that works for you or you'll never fly again.
I appreciate all of those arguments and certainly the situation and the delay. But I think the starting point, right, is that this is a special issuance license and the FAA is essentially saying a 54% risk is too high. And we are going to approve some other drugs that work in different ways with much lower risks. But just as a sort of baseline starting position, 54% is too high of a risk. And so what is our basis to disagree with that?
Well, Your Honors, your basis is the regulation itself. It requires the FAA in 67.401C to provide professional consideration of all available information regarding the person, the pilot. They have to examine Mr. Solondz's medical records. And moreover, your point about 54% is too high. Well, there's two things to that. The one, as I had just mentioned, on the dosage that Mr. Solondz is on, the FAA has already acknowledged only 14% compared to 10% placebo. So already they've undercut their own argument. But more to the...
I didn't mean to interrupt you. Go ahead.
Oh, pardon me. But I would say more to the point, the FAA, the other SSRIs, antidepressant drugs, the FFA has approved. And again, when I say approved, let's think of this as the difference between a green list, something like Tylenol that doesn't raise any flags, a gray list, such as the other antidepressants, Lexapro, Zoloft, things like that, which are eligible still for a special issuance where the FAA has said, it's okay that you're on those. You can't get a general certificate because of their sedative effects, the potential in the general population, but we will look at you individually, examine your medical records, and institute an entire year-long SSRI protocol, a protocol Mr. Solondz has been through multiple times and passed and performed by Dr. Dennison, again, the FAA HIMSS doctor. So that's where the arbitrary and capricious part comes in, where the FAA has created this extra blacklist, unpublished, without any rulemaking, without any comment, that says certain pilots on certain medications are prohibited, period. They will not be treated the same as their fellow pilots who get individualized treatment.
So
Instead,
that I think is the crux of your argument, is you're arguing that he did not get individualized consideration.
that's correct.
But I take the FAA to be saying, well, he did. He applied under the special issuance provision. And that's, I take it that's the only provision that's at issue before us.
That's correct.
And they looked at his records and they decided no. And now you're making what I understand to be sort of a procedural claim that they didn't actually do an individualized special issuance review. They made a categorical determination based on the characteristics of Remeron. Am I right that that is your position?
Yes, it is. And in that regard, this case is exceptionally close to the Irwin case that this court decided just 2 years ago. In Irwin, and it's briefed fully in our brief, but in Irwin, a pilot who had a special issuance that prohibited the use of alcohol inadvertently ate some pulled chicken, that had been cooked in alcohol and failed a test the next day. Eventually, this court overturned the FAA when the FAA insisted that, sorry, one failed test, regardless of all of the evidence submitted, including forensic toxicologists and everything else, a mountain of evidence Irwin submitted about his individual case and proving with no evidence to the contrary by the FAA, but the FAA held the line and said, sorry, nope, we have a bright line. We're not going to look at your individual evidence. We're just going to say, sorry, special issuance, you're done. That's exactly what we have here, where it's not about whether or not Mr. Solondz is safe to fly on Rimron, because the mountain of evidence, 4 years of medical evidence, shows he is, that he has no sedative effects. He is not one of the ones who suffers from it.
There's sort of a medical question embedded in this, which I'm not sure anyone addresses, which is, does a history, assume he does have great evidence that over a period of time, he has not suffered this side effect. Does that mean he's unlikely to in the future, that the risk has gone to zero? Or does it mean on a drug that generally has, if we assume the number is 54%, there's still some meaningful risk that the side effect could start? I didn't see anyone address that.
Right. And Your Honor, that's because there is a little bit of a medical part of that. First, though, I want to correct, 54% is not accurate because the FAA's own studies show the dosage he's on, it's only 14%. And so that's already a big difference. But with respect to, this isn't something like Benadryl. That's the studies that are in the record, talk about this. It's not something where the somnolence or the drowsiness is unpredictable. Indeed, the trucker study about commercial truck drivers that the FAA cites in its denial, saying there was sort of an increased risk, talks specifically about this and comes to the conclusion, taking a single large dose at night before bed essentially alleviates any of the sedative side effects, that they're not found anymore. That's the recommendation of this study, and I believe the recommendation page with that conclusion is on page 671 of the record. And again, this is the study that the air surgeon cited in its denial as a reason why Rimron is apparently a blacklist as compared to the other SSRI antidepressants, which also have sedative effects anywhere between 30 and 45% in the general population, which, it's okay, it's less than 54%, but that still means 70 or even 65 pilots out of 100 could be having, a risk according to the FAA's logic. And yet they still
Some of the conditionally approved SSRIs have side effect rates of 30 to 35%. Is that where is that?
Those are in the studies that are attached at the end of the record, the FAA studies. That it brought in. The point being, the FAA has used hyperbolic language in its briefing and in their surgeon denial to say there's a significantly more risk. Well, I'm not sure that that's a very significant different risk, but more to the point, it doesn't give the individualized assessment that the regulation calls for. And the FAA has produced no rational basis and no reasoned explanation as to why it is treating Rimron differently and why, under the same special issuance regulation, the FAA can pick and choose which antidepressants a pilot is allowed to or is entitled to and given an individualized assessment of their own medical history to determine if that risk ever manifests, as opposed to Mr. Solondz, who has been denied the individual review of which would show that with more than 4 years of use, the COG screenings done multiple times by the FAA doctors show no risk, no difference between the general pilot population. And really that gets to the crux of it, because I recognize 54% may sound like more than half, general population. But that also means you're grounding 46 out of 100 pilots for no good reason. That doesn't make any sense either.
Counsel, I just want to be clear. When I read the record, and maybe I misunderstood it, I don't see a basis for your saying that the FAA never considered your client on an individual basis. All right, it goes on and on and on about your client's circumstances. And it acknowledges that your client has had these other medical evaluations and opinions. But then it says, consistent with its statutory obligation, that it has classified this particular drug in a certain way. And it's simply not going to move off that because of its concern about, what it says, and we're not physicians, are the inherent qualities of the medication, and that there are all kinds of other things that aren't like this. And your client's position, as I understand it, is that what the FAA failed to do, and let me be clear that I understand the position, is that the surgeon didn't critique each of the evaluations that your client proffered or produced for the record. In other words, I don't see the record in this case as substantiating a granting of the petition on the grounds that the agency failed to consider the issues before it and failed to consider the evidence that was presented relevant to those issues, but rather along the lines of Judge Garcia's question, consistent with its obligation about medical safety, air safety. It's simply not going to approve this drug. And you say there was no rulemaking, there was no nothing. But at least now we have a statement by the FAA as to its position. And we may not agree with it in the sense that your client is saying he disagrees with it. But what does the court say? In other words, it's not the typical arbitrary and capricious situation. It is, they've looked at some studies and the surgeon says, here's where I come out.
Yes, Your Honor. So I can understand that is certainly the position the FAA is trying to advance. However, this court does have a reasoned way of approaching the case. And in Irwin.
Tell me what that is precisely.
Yeah, so precisely. So in Irwin, again, this court only 2 years ago, it explained that the court's role is to determine whether the FAA has examined the relevant data, articulated a satisfactory explanation that does not fail to consider important aspects of the problem.
And that's what my question went to. That's the standard.
Yes, Your Honor.
On these FAA.
Correct. And Your Honor.
Cases. Yeah.
Right. And in Irwin, the FAA did the same thing it's doing here now, where it said, sorry, we have a bright line rule. It doesn't matter any evidence you've put. We'll give lip service that you submitted it, because in Irwin, the FAA did include a sentence saying, we note you submitted medical evidence to the contrary, but it did not analyze it. It did not give any explanation. It merely said, we have a rule that any failed alcohol test means your special insurance is canceled and you're forever ineligible, period.
Well, counsel, it is.
That's the problem here.
You may still have a compelling argument, but Irwin is very different, right? Irwin was, you have a positive alcohol test and he had specific evidence showing that it wasn't because he drank anything that he shouldn't have. And this case is all about, maybe the FAA should have said more, but it would be totally consistent to say, we are going to have a categorical rule against Remeron because we're not going to take the time when the risk is so high, they would say, and to do case-by-case evaluations. We will for other drugs, SSRIs, which have been around longer and we understand how they work. And we've decided to approve them in a cautious case-by-case way. We just haven't gotten there yet with this tetracyclic, type of drug. That's not, in other words, you could justify a categorical rule, and the very nature of that categorical rule would be they could justify not looking at your individual evidence, right? They had administrability reasons and better science than you think they have.
Well, Your Honor, I would say that could be the case, but that's not the case here. The FAA did not develop any of that in the record. It certainly didn't even make an administratability argument. The FAA has produced no reason to justify a blanket ban on Remeron and a refusal to conduct the individualized assessment that the regulation requires on pilots on Remeron, other than to say, using hyperbolic language that there's a significantly greater risk, while in the same breath, or well, this next sentence, same paragraph, but next sentence, noting that actually the risk on the dosage that Mr. Solondz is on, the higher dosage, gets down to only being a 4% difference between the placebo group. And again, I can't stress this enough. The FAA has not adduced or even claimed any evidence that this risk is something that's sort of intermittent, that drowsiness comes and goes. The opposite is true. The FAA has developed its SSRI protocol to do a longitudinal study of each airman on an antidepressant. The protocol is discussed at length in our brief, and that's what Dr. Dennison based his evaluations on. And he followed that same SSRI protocol.
Did
Yes.
you develop the argument and the facts that, for example, you were saying this is a 54% rate, but in fact, we have a study showing it's 14%. And also providing them information about the drugs they have approved that shows it's 30 to 35% in order to really tee up this kind of arbitrary decision-making?
So
Is that in the record?
I'll say yes and no, Your Honor. The other drugs that were very recently approved were approved during this process and within the last year. So no, we did not include those studies. The FAA, though, provided a few of those studies for the record and insisted on including.
What about as to the SSRIs that since 2010?
Yes, those are in the record. They're in the record. They've been attached to the many letters, the many requests and the applications and the requests for reconsideration. They're discussed at length. For example, Dr. Dennison's 2022 report at the end of 2022, when he finished the second year of an SSRI protocol, the second one-year instance of going through the entire SSRI protocol, Dr. Dennison even explains, I've looked at and reviewed the specific studies that have been presented. And these are the same studies that the FAA is now citing in its denial, in particular about the long haul effect on truckers. And which comes to the conclusion, do a single high dosage at night and you don't have the sedative problem. Which, again, Dr. Dennison saying, hey, this is what Mr. Solondz is doing. And there's not a sedative problem, and it hasn't been a sedative problem observed for the 4 clinical years now that we've been doing it. And really, Your Honors, this gets to the heart of the issue of what a special issuance is even about and why this is an abuse under the APA and arbitrary, capricious, and contrary to law. The FAA has created a situation, and its argument that Rimron is just blacklisted, period, that's fine with respect to a general aviation medical certificate. There can be qualifications, and if Rimron is one of the prohibited medications, then the pilot does not qualify for the general certificate. That's fine, but that's why the FAA created a separate regulatory scheme and administration for special issuance, because that is the opportunity for pilots to demonstrate that they do not suffer under a medical condition that prevents them from getting the general, but also prevents them from doing the piloting, from being safe, from being effective. And that's why the FAA created its SSRI protocol for antidepressants. Because the FAA has determined that if you pass that protocol and you're on these 7 slightly older antidepressants, then you've passed. You're eligible for a special issuance because that necessarily shows that it's in the public interest and there's not a public safety concern. Well, Mr. Solondz has done that same protocol repeatedly for years, but because the FAA has, without any rulemaking, without any comment, and without any actual explanation or acknowledgement that this drug has ever been blacklisted until this appeal, has said, sorry, that's just not enough. That just, period, we have a bright line rule. And again, that, Your Honor, Judge Garcia, I know you think Irwin has some differences, but it does get to the point that when administering the FAA special issuance program, it cannot pick and choose what evidence it looks at. It needs to look at the individualized medical evidence to assess whether that individualized medical evidence overcomes this presumption of some safety issue. And here we know it does because we have 4 years of studies, not doctor shopping, but from the FAA HIM psychiatrists and neuropsychologists.
If we agreed on this argument, there's still the FAA said sort of like a conditional denial based on these other diagnoses. We can't approve you now until you provide us with more information. One question is just, is it true that you've not provided that additional information because you don't think it should be necessary? Or has he provided the additional?
Your Honor, I would say that additional information had been provided many times to the FAA, but because we've been on a 4-year hamster wheel where we submit something and then 6 months to 9 months later, we get a response, some of it may be outdated. So as part of a new special issuance and additional eye exam, that's fine. But I will say the other medical issues that the FAA cites and the air surgeon cites, I mean, they're clearly protectual. I mean, the AFib issue, the atrial fibrillation, was resolved. The special issuance is in the record that was issued 20 years ago when that issue arose. Since then, it had been resolved, and Airman Solondz had proven the atrial fibrillation issue was resolved and had gotten regular, the 100% general certificates for years. And yet it's dredged up now just to throw more mud on the wall and distract from the issue that the blacklist is RIMRON. When you go to the...
Keep referring to the blacklist of RIMRON. Is it not permissible for the FDA, Freudian slip, the FAA to not act as the FDA, for the FAA to have general disqualifications based on certain medications for a period of time unless and until it determines that they don't ordinarily pose a risk? Is it your position that something that precludes a non-special issuance license must nonetheless be scrutinized by the FAA in terms of the individual pilot's experience on that medication? That there just isn't a role for a categorical hard stop. People on this medication aren't going to get special issuances, or is your argument not that broad?
Well, Your Honor, I'd say it's more towards the latter, but it doesn't have to be that broad. And certainly this court need not issue an opinion that broad. The court here can focus on the fact that the FAA has approved several antidepressants and put in place a specific protocol because all of those antidepressants in the general population have an incidence of significant side effects that could affect aviation safety. That's why the FAA created its SSRI protocol. Here, the FAA has said, sorry, we're going to single out a different antidepressant, not tell pilots that it's singled out until after they've applied and gone through it, ignore whether or not that other antidepressant has manifests the side effects we're concerned about, and instead just treat it differently.
In the individual's case?
As a categorical rule.
Because they've said it manifests as a categorical rule, and there are some qualifiers on that with lower doses, taking it at night. You haven't mentioned the after 2 weeks on it, but there are various things in the record that say there may be people who take this who wouldn't suffer these effects. But my question was more a legal one, whether your position is inconsistent with a kind of general no-go on a medication, even if there may be individuals who would still be unaffected by the reasons for that no-go decision.
Right. Well, to that, Your Honor, I would say the special issuance regulation that the FAA created requires an individualized assessment. So if a pilot does not qualify for the general certificate due to the use of some medication that the FAA has not greenlisted, then the pilot's alternative is either give up their career or pursue a special issuance. And again, the point of a special issuance is not to say we're exempting or ignoring some particular safety hazard. It's to say, is there a reasonable way to minimize, mitigate, and even eliminate the risk that prevented a general certificate? The
We understand that, but isn't Judge Pillard's question, don't you have to answer her question directly?
Pardon me, Your Honor? Could you repeat that?
I don't understand that to be an answer to Judge Pillard's question. And that's what we're searching for here in terms of what your position is. You have repeated that an individualized assessment is required. And you define it one way, and the FAA has defined it to allow a blacklist.
Well, yes, Your Honor, I would say in the Irwin case 2 years ago, this court found that having a categorical rule and applying a categorical basis for denial to a request for special issuance was arbitrary, capricious, and contrary to the Administrative Procedures Act.
In
guess
the
So we are asking
circumstances
for
of
that here.
case, there's no point in our trying to re-argue that case. We're trying to understand what the legal principles there mean in light of the statutory and regulatory scheme before us. And that's what I thought you have to answer Judge Hillard's question, because your answer is, as I understand it, that the FAA could not interpret a special issuance to include blacklisted drugs, period.
That it can't rely
Pardon
on
me.
that kind of categorical determination, that it has to scrutinize the basis for its own categorical no-go determination and to test whether it would apply to each individual seeking a
And it's
special.
not only that, but as I understand it, it's that it has to do its own study of the particular drug, decide what it thinks, and whether any evidence presented to it persuades it to the contrary, and then do its own examination of your client, even though the FAA says very clearly that whether you are prescribed a certain drug is a decision for the airman's or airperson's personal physician, not the FAA.
Well, Your Honor, respectfully, I'm not quite sure that I would characterize our argument as that. I don't believe the FAA has to conduct its own medical studies. I think that's outside the scope of their expertise, and we're certainly not advocating this court create some sort of rule like that. However,
but if the FAA finds that a drug, in its opinion, in light of the evidence before it, should be blacklisted, it cannot do that under your view of what the special issuance requires. That's what we're trying to understand of your position.
So our position is that a blacklist is impermissible to the extent the FAA is using it as basically a rubber stamp no, and refusing to look at any contrary medical evidence, and in particular medical evidence of safety, individualized medical evidence of safety that the airman presents with respect to their application for the special issuance.
Suppose the FAA and the surgeon wrote a pilot a letter that said, we have examined all of the studies going back 20 years, and the particular drug that's being used by this particular pilot has a 10% risk associated with it. And it lists the risk, including sleep apnea, constipation, nausea. Yeah, it just goes down the list. In your view, as a matter of law, would our decision in Irwin require granting the petition?
So let's be clear, the petition is not asking this court to do something it's clearly uncomfortable with, and that would be substituting its own judgment as to whether this airman is safe. The petition is asking the court to order the FAA to actually consider the individualized medical evidence submitted. So, Your Honor, to your question, your hypothetical, I think the issue is that the FAA can look at any studies it wants and create any blacklist it wants for a general certification. But the FAA chose to create in its regulations an alternative process, the special issuance process, which requires individualized assessment of the airman's particular safety and records. It's up to the airman to produce those records, to go through any of the required examinations, to submit the required information. Here, Mr. Solondz has done all of that. So that really is the issue for this court. Can the FAA essentially merge its general certification requirements with the special issuance certification requirements so that the blacklist for a general medical certificate overrides and it envelops, really devours the special issuance process? And the answer has to be no. not just because the FAA wrote its regulations to create two separate divergent processes, but also for important public concerns, including public safety. Your Honors, early in the brief, we opened with some extensive quotes from bipartisan, the Aviation Authority and the Transportation Committee of Congress, and those are in the record. The FAA had it to consider because Congress has noted that there's a mental health crisis with pilots, that pilots, because of the FAA's secret blacklists, are afraid and are not seeking treatment, are instead self-medicating or foregoing treatment altogether. They're afraid because the FAA is not doing its special issuance procedures and not following them, and instead is taking the same rubber no denial stamp that it used for the general medical certificate and applying it to the special issuance without actually looking at the airman's individualized medical records. And keep in mind, these are individualized medical processes that the FAA is asking the airman and sending back a denial letter saying, if you want a special consideration, go get these extra exams that show that this medical condition is not a concern. The airmen are doing that, including extensively Mr. Solondz for 4 years, at their own expense, at their own time, while their own careers are interrupted. They're ultimately the FAA trained, licensed, it's a very small pool of doctors and psychologists that the FAA allows to do these examinations in the HIMSS program. Those same FAA experts are saying it is not a problem, that this particular pilot, it does not suffer any of the deleterious side effects that the FAA was concerned about. But the FAA still continues to say, sorry, we stamped your general request denied because of our blacklist. So now we're going to use that same blacklist to deny all special issuance, despite inviting the pilot to continue the process and support medical information to the contrary. That, Your Honors, is what's arbitrary, capricious, and contrary to law. And that's what Your Honors have an opportunity to correct, to order the FAA to actually follow its special issuance process, to look at Mr. Solondz's uncontroverted longitudinal medical records and determine whether that sedative effect is present or not. If Your Honors have no further questions.
We'll hear from the agency.
Thank you.
Mr. Carver, morning.
Good morning. May it please the court, Ray Carver for the FAA. The federal air surgeon has the responsibility to ensure that pilots, and especially commercial pilots such as petitioner, are able to perform their duties without endangering public safety. In this case, the federal air surgeon made a reasoned determination based on the available medical and scientific information and clearly communicated those reasons, the reasons for denial to the petitioner. It's undisputed the petitioner is not medically qualified under the applicable medical standards. So instead, he challenges the FAA's exercise of its discretion in denying a request for an exemption from those medical standards. Courts have acknowledged that the review of an agency's exercise of discretion.
I mean, there's tendentiousness on both sides in the briefing, but Mr. Solondz says he's not seeking an exemption. He's seeking an individualized determination that he meets the standard, which is, I think, appreciably different. If a airman would want to prompt the FAA, I mean, in a lot of circumstances, you could petition for a rulemaking. Is there a way for someone to effectively petition for a rulemaking that the FAA would reconsider its categorical disqualification of people taking Remeron?
So I don't know that there's a specific way to prompt a rulemaking, but I would say in this case,
Or
the FAA,
reconsideration of the policy?
yes, the FAA continues to review these policies. And as you can see from the Federal Air Surgeon's letter, she notes that there were several drugs that were approved in the last year that were added to the list. And also, you can see from the Federal Air Surgeon's decision that she actually reviewed the new article that he had submitted with his application. She reviewed it, she weighed the evidence, and came away with a conclusion regarding the impact of that article on her decision. So
Where are you pointing to?
on page JA 12 of the record, it is the Casper article that was provided by petitioner's counsel. And the federal air surgeon specifically states that she reviewed that article and notes that while, as the petitioner recognized, the FDA's information says that there's that over half the people that take this medication experience somnolence or sedation. The federal air surgeon does note that this Casper article does say that there are some studies that say that some people experience it, or some studies see it at, possibly a 14%. But she goes on to review that article and noted that that article simply provides theories. And as we stated in our brief, the Casper article highlights this as a paradox in the data, and then goes on to speculate what this could possibly be and what the impact may be. This is far from conclusive evidence of a lesser
So are
risk.
you saying we should read this? His argument has a lot of intuitive appeal. The FDA has this really high rate, but it's based on generic doses.
Mhm.
This is specific to the type of dose I'm taking. And this study, which is based on pooled studies, shows just a 14% rate. Are you saying we should read this as that the air surgeon has determined that that study's report of 14.8% is unreliable? Or just that they didn't come up with a great explanation of why that's happening, but that sure seems to be the rate when you use that dose?
So I would say that that article does not overcome the risk that's posed by the FDA's information. So the FDA's 54%, they acknowledge the 54%. That 14%, they acknowledge that, or this article states that that's been seen in several studies. However, it can't even explain where the reason for that reduction.
I guess it's kind of a simple point, right? Like
Yes.
the FDA, as it comes to us,
Mhm.
it just has a number, 54%. And he's saying, here's another number. And it's the number that's at the dosage that I take. We don't have any other information on the face of this, other than it sure seems like the 14% is the more relevant number than 54.
So that's where we rely on the federal air surgeon's review of these records to determine the impact of them.
So in your view, the federal air surgeon would be empowered to, even though she didn't do it here, to say someone on Remeron, given enough sort of medical records on that person, enough relevant medical tests conducted, that the air surgeon could, under a special issuance review, find the person qualified.
Yes, if the federal air surgeon determined by looking at the available evidence that the risks associated with Remeron could be mitigated by something like the SSRI program, then certainly she could issue a special issuance medical certificate.
So it doesn't have to be moved to the conditional review or the conditional approval category that the SSRIs have been moved to in order, or these other, I guess, I don't know if bupropion or duloxetine and venlafaxine, I don't know what category those are in, but they've been, so even with the Remeron in the category that it's in now, that doesn't preclude special issuance? Is that what you're saying? Without moving it into a different category?
Correct. If there were additional information that were to come out to show that the risk is either, the risk is much less than what has been seen before, or that it could be mitigated sufficiently through, the SSRI program, the monitoring, whatever conditions might be placed on it, then certainly the federal air surgeon could rethink her stance on Remeron.
But that would be a categorical
Right, that's a
judgment, right?
general question. What I'm asking, and sorry if I haven't been clear, what I'm asking is, are there drugs that are, practically speaking, a blacklist? Like, you're basically special issuance or general issuance. If somebody's on certain drugs, you're gonna think that's too dangerous. And therefore, even within the context of special issuance, the air surgeon can say, no, I'm sorry, I see that. And I'm not really gonna look at your experience on that drug just because we haven't gotten there with that.
Yeah.
We're not yet comfortable with individual treating, clinical opinion about your flight worthiness on that particular. Is there such a category or not?
So I believe that the federal air surgeon can make that determination. I disagree with petitioner's assertion that there's a blacklist on medications.
Well, it's a freighted term, but I guess
Yes.
I'm trying to come up with I'm calling it no-go, that there's, might be certain medications where it's just like that medication and flying a commercial airplane, we're not going to get into the details in anyone's case because we just don't think we can do that. Is that a meaningful analytic category as a practical matter that the FAA uses, or are you?
So certainly we see that with Remeron here, where the federal air surgeon has reviewed this and for years has been clear that the use of Remeron is not acceptable in terms of aviation safety due to the risk posed.
But
So-
if she had, and this is the separate question, and this is really a legal kind of policy schematic question, not a question about his record. If somebody came, presented their records and their doctor said, yeah, this person's on Remeron, but he was very drowsy for the first 2 weeks, consistent with some of the studies, including the study the FAA relies on, but zero problems with sleep. Happens to be a person who's never needed much sleep, blah, 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 high level of alertness, in fact, extraordinary off the charts level of alertness, and whatever else is in the record. If the air surgeon thought, yeah, I'm not going to change my general view on Remeron, but this person seems good to go, could she, without reassessing Remeron in general, grant a special issuance license?
Yes, there's nothing preventing the federal air surgeon from issuing a certificate or a special issuance in those terms. So if there is information available that, like I said, would mitigate that risk, then the federal air surgeon would be able to grant a special issuance. And that's why I push back a little bit against the blacklist, because this isn't a published, this isn't a rulemaking of, these certain medications are on a list and they're always a no-go. This is a decision that the federal air surgeon makes by reviewing the available information. And in this case, 54%, over half of people on this medication experience signs.
But maybe we think about it this way, in terms of characterizing what position the air surgeon took in this order,
Mhm.
am I right that the position is, based on the available evidence, I am going to maintain my categorical rule against allowing the use of Remeron?
I believe
Like
that
this
is, I believe that is the
Might have
conclusion here.
discretion to make exceptional, whatever other thing, but just as we stand, I'm staring at the list that is published on the FAA's website that says conditionally acceptable medications and has many listed. And then under a bright red box, unacceptable
Yes.
medications. And so this is the position that the air surgeon is taking. I just want to,
Yes.
this is how I'm thinking about the case, right? There's been some confusion over whether the argument is that the FAA can just never have a categorical rule about a drug. Let's just put that to the side. The question at a minimum has to be, has the FAA adequately explained why it has a categorical rule for this drug?
Mhm.
And on that, I would love to hear your best arguments that the FAA gave a sufficient explanation, because when I read this, it says, basically, there's a high risk it acknowledges this 14.8% number, and then it just asserts the one rationale is the approved drugs have, quote, much lower rates of somnolence. Doesn't say how much lower, doesn't say any of the sorts of things I might have expected it to say. Why is this enough of an explanation of a categorical rule?
So, Your Honor, first I go back to the standard of review here. The Supreme Court stated in State Farm that that the court must uphold a decision of less than ideal clarity if the agency's path may reasonably be discerned. In this case, you clearly have a path here where the federal air surgeon reviews the FDA prescribing information. It says that over half of those people experience somnolence. And then it acknowledges the petitioner's article that says, okay, well, in some cases, this may be lower, but it doesn't provide a solid conclusion. It provides theories.
But the FAA itself relied on this Ramekers
Yes.
study, and that study found that the sedative effect is much alleviated by taking it at night, as Mr. Solondz does. And also, I believe it said that the sedative effects are really present during the first 2 weeks. And Mr. Solondz has been, he had to wait, 6 months. He's been on this drug for a very long time, and his doctors are saying no sedative effects. So if the air surgeon were persuaded by that, it's your position she could have, notwithstanding the red box, she could have granted for him, but that it was also within her prerogative, given the red box, to say no.
Yes, I believe that is true. If the federal air surgeon had reviewed that information and believed that the risk could be mitigated, that it was within the federal air surgeon's ability to grant a special issuance there. However, on the flip side, the federal air surgeon also has the ability to look at certain medications and certain medical conditions, for that matter, and say that there are certain risks that are just simply too great for a pilot, and especially a commercial pilot, to be flying in aviation. Her primary responsibility is to that of aviation. And
Okay, so let me follow up on that point. And this is on page 20 and 21, which is, JA 12 and 13. So the surgeon says she's looked at this paper, all right, and that's the reference to the 14%. And the only reference I'm aware to the 14% is in this 1997 study by Casper, right? And she critiques it as theoretical, basically, and speculative. Then she says, I also note that a 1998 study by Ramekers, O'Hanlon, et cetera, assessing the performance while driving and using this drug at a dose of 30 milligrams daily. This study reported poorer performance with keeping lane position. All right. So she goes on and she says, given the available evidence and my duty to ensure, I'm unable. But then she goes on to point out these recent changes that have been made. But she goes on as to this particular case to have paragraphs about this particular pilot's other medical conditions. And you'll find that at JA 13 in both the paragraph starting second and the paragraph starting third. And then she has a conclusion about sleep apnea and other sleep conditions. So what I want to be clear about in terms of the adequacy of her explanation, it talks about this Remeron drug, what the evidence was before her, what studies she had and how she interpreted them, and then talks specifically about physical medical conditions of this particular pilot. petitioner's counsel has objected to the surgeon's reference to those other medical conditions. And I'm not clear, other than earlier a statement in terms of saying, well, you never mentioned this before, but now you're mentioning these conditions now. Why this court should not consider that as part of the surgeon's complete explanation, dealing with the historical view of the drug, the study that the pilot offered, this Casper paper, and then looked at a study done a year later, and then talked about the particular physical medical conditions of this pilot. Why? What I'm trying to understand from petitioner's argument is why it would be improper to consider the pilot's individual physical conditions, since he wants this individualized and says the surgeon must do it. And that's why I questioned him as to this hypothetical, because I think it's close to saying that there must be a new evaluation by the surgeon of this particular drug. And he doesn't say she has to do the study, but she's looked at what he's given her. She's looked at what they had, and she's looked at him professionally. So if his view is that nevertheless, under Irwin, that is inadequate, other than filing a lawsuit, is that the only remedy a pilot like the pilot before us has? Because your answer was, well, there's no way to file a petition for a rulemaking.
So the remedy in that situation, again, to provide whatever additional information, additional studies that they would like to provide in that reconsideration process. And if the federal air surgeon determines that that doesn't mitigate the risk, they would be able to challenge it as they have. But again, the federal air surgeon is uniquely competent, is within the unique competence of the federal air surgeon to make these kind of determinations. She has to evaluate the scientific studies, the possible symptoms that could come.
Okay, counsel,
yeah.
I'm going to interrupt because I just want to be clear about this. The FAA, are you taking the position that an individual pilot, in seeking this special issuance, would have to himself or herself fund a study to show that since these studies in the past century, a lot has happened, and these studies, I mean, those are very expensive, and who has the incentive to spend that money on this type of study? You go to Congress and ask Congress for a special appropriation. I mean, counsel says all these congressmen are upset about this blacklisting, but do they give the FAA the funding to do these studies?
So I'm certainly, I don't mean to insinuate that we would ask him to go out and fund some study, but the FAA has to rely on the studies that are completed in the community. And we look at the FDA's information, the studies that they rely on.
And I don't think we're in any position to question that, but the studies that the FAA itself relies on, like,
My question, however, counsel, as you appreciate, was trying to understand this whole process here. Because we're raising a lot of questions that may be beyond what the court can decide. but to understand what's happening to an individual pilot who, as counsel said, has done everything right.
So exactly. The studies that the FAA itself relies on, like the Ramaker study says much less somnolence if the medication is taken at night. The Wingen study that the FAA itself relies on says the drowsiness is mitigated after the first 2 weeks of taking it. And so the question, and as you've noted that, well, there's 6-month waiting period for someone who's gone on a new medication. And I guess the question that I understand Mr. Solondz to be asking is why, given that the air surgeon has the authority to decide that the risks, even of Remeron, don't disqualify me, how could my record possibly be more the poster child for the person who is entitled to that treatment, to that special issuance? And I don't think he's saying you must give it to me, but he's saying, I don't see your explanation that's responsive to my particular case.
So the federal air surgeon goes at length through his record and acknowledges on page 10 that his conditions are stable on treatment with normal performance and testing. But then on page 12, when she starts to talk about the medication, she states that that doesn't overcome the risks that are involved in that medication. And certainly petitioner disagrees with the judgment that was made at the end of the day, but it's the federal air surgeon's judgment based on the FDA information and those particular studies. Like the federal air surgeon said, I mean, certainly the Ramaker article does talk about some reduced risk, but it also states in there that there was a poor performance on driving on day 16. And so it's those things that, that is the federal air surgeon's particular area of expertise, is to review the methodology and the reasoning behind all of these articles. And she clearly did. She clearly read these articles. She evaluated them and put weight on them. And as the court required in State Farm, she made a rational connection between the facts that she found and the conclusions that were made. And, petitioner, he states that he's, making this more of a procedural, we want to make sure there's a review, but he's clearly wanting to substitute his judgment. He's asking that this court.
To be fair, I mean, the Judge Rogers was pointing to these additional paragraphs, discussion of optic neuritis, which the treating doctors have said is resolved, is normal. The malignant melanoma, just completely wrong. And the air surgeon says, your doctor said that the diagnosis is melanoma in situ, not malignant melanoma. And then goes on to say, malignant melanoma can pose a high risk. Completely irrelevant, because that is not his diagnosis. And then sleep apnea, he's under the compliant treatment that's mentioned. So there's a feeling not unwarranted in reading this that it is hard to discern a reasonable path, like what really the decision is based on.
So the final three there, the optic neuritis, the malignant melanoma, and the sleep apnea, are based on the federal air surgeon's determination that she needed additional information. So that's the decision there. I mean, specifically with the malignant melanoma, she acknowledges that there's some conflict in the record. The record also states that he has malignant melanoma. And so when she asks for additional records, she's asking in part for all pathology specimens reported. So she's looking for the background, the complete medical file for that malignant melanoma so she can look at it and determine, okay, was this melanoma in situ? Was it malignant melanoma? Which was the correct diagnosis? And the same for optic neuritis. She states in there about the risk of it developing or of it worsening and I believe developing into MS. So she's asking for continued evaluations, continued review by his doctor. And so these are ongoing reports that we would normally ask for. And so and I think she makes clear, if he were to not be taking Remeron, these are the things that the FAA would need in the future. And I think that's the federal air surgeon's attempt to try to give a holistic review and to be very open and honest and say, look, if you stop taking Remeron, we're still going to need some other things. And so she's trying to be open and honest about what the FAA's concerns are and what might be needed in the future, notwithstanding the Remeron.
That's just one last question about, so I certainly appreciate the argument that basically she looks at the studies and concludes Remeron poses too high a risk of aviation safety. That's not the kind of thing that we have the position or role to question on its face. He then has an addendum to that. You have approved other drugs, conditionally, with significant rates of somnolence. And it looks like the whole sum and substance of what could be a response to that argument is the sentence that says, those have a much lower risk of somnolence. And why shouldn't we at a minimum be remanded to understand how much lower? Why is that significant? Why can you have case by case for those drugs, but not for this drug? Can you give sort of a direct response to that? Why is that sentence enough? Is there other material here?
Yeah, so I don't think the FAA, I don't think the federal air surgeon was required to go point by point, every single detail. The courts said that, an essay is not required for the disposition of every application. And in here, the federal air surgeon drafted a 7-page letter to try to address each one of his conditions, address the articles that he provided, and tried to give weight to each one of those. And specifically, she stated that they have a lower risk to somnolence. So I don't think that she's required to provide each and every detail about the level of risk or somnolence in one medication versus the somnolence in the other. The requirement is not that she prove every single point and respond to each one of the arguments. The standard of review here is to determine whether she is connected. She's made a connection between those facts and the decisions made. And I think clearly here, she has done that. Petitioner may disagree with the conclusion that she's reached, but the federal air surgeon has clearly communicated the connection between those facts.
So am I right in reading, I'm not sure how to read it, that the reference, sleep apnea is referenced at the end of the letter, but it wasn't a basis for the denial here?
My reading of it was that sleep apnea would require the ongoing information that's requested. So sleep apnea, the program does require that they provide ongoing data regarding their
That's
CPAP.
provided here, but it's not the basis here because the Remeron is the basis.
I believe the primary basis would be Remeron.
And so too with the putative malignant melanoma, not the basis of this denial, but just saying if we were to go forward, if we were to clear the Remeron hurdle, that we'd need these pathology reports and other information.
Correct. The federal air surgeon saying, look, Remeron, we cannot issue you a special issuance, but also I can't make a decision at this point regarding these other conditions because we just don't have the information.
And the optic neuritis being resolved, nonetheless, this denial letter says quarter to half of people with it end up with MS within 15 years. Doesn't seem like 15 years would matter. Solondz is 2 years away from mandatory retirement.
Well, that's retirement from the airlines. They would still be able to fly commercially, just not for an airline. And of course, they'd be able to fly privately as well in the airspace.
Excuse me?
They would also still be able to fly privately as well, which is, still a concern.
All right.
Thank you.
I think we have, Mr. Nagy has, Nagy or
Nagy,
Nagy has, 2 minutes for rebuttal.
any honors? Thank you, honors. All right, so just a couple of points I want to address that were really raised before. One, there's a lot of talk about what exactly is the burden on the airman and what must they prove, in particular with respect to studies and such. But I want to make 100% clear that the issue here in this case, if it can be summarized as succinctly as possible, is that with respect to Rimron, the federal air surgeon is relying wholly on generic studies and is not relying on the individual medical evidence from the airman, despite the air surgeon relying on individual medical evidence for all other antidepressants. And in particular, we see this in the air surgeon's denial, on page 12 of the joint appendix. One of the last sentences about Rimron says, "This paper," referring to the Casper article and study, "does not refute the possibility of mirtazapine still causing sedating effects." To be clear, that's a telling admission because in the next paragraph, the air surgeon explains, well, the other antidepressants that we have a separate procedure for also have sedating effects. This is the arbitrary and capriciousness manifest. Now, with respect to other medical conditions, I want to be clear. I think our briefs do a pretty good job of explaining why those are pretextual. And in particular, though, it seems
For what?
to bolster the Rimron, sort of hide from it. In particular, with the
You don't
CPAP.
just mean arbitrary and capricious, inadequate.
Excuse me.
So you really, pretextual is usually a pretext for some kind of bias as
Yes.
opposed to just arbitrary, inadequate.
Right. Well, I would say the sort of bias is towards protecting the unpublished blacklist of medications and the ability of the air
I don't think
surgeon.
it's there's nothing that precludes the FAA from having a red box on certain
Well,
medications. At least you haven't pointed to anything.
yes. Well, I will point to that the FAA's attorney been up here explained that that with respect to having a sort of a bright line red box that the air surgeon has within their discretion under the regulations, and indeed the special issuance regulation calls for the individualized assessment despite to use your honor's words, a red box of something. So the failure to do that individualized assessment and instead just to rely on the red box with the special issuance would be the arbitrary and capricious. But I really wanted to get to with respect to the CPAP issue as just one example, since that just came up as this potential, well, it would still be denied because other information needs to be presented. And two things, your honors, you've seen the copious record, the years of applications submitting this medical information and then not getting a denial for so long that then the next round of the denial says, well, hey, get off Rimron, and if you do, we'll reconsider you, but by the way, resubmit everything you already submitted. I'll say with the CPAP, that's particularly telling because the CPAP condition, and I believe we have the site in our brief to the FAA's guidance on it, that's a standard condition of a special issuance. These aren't preconceptions. The only precondition is the airman's willingness to abide by the CPAP rules and recording requirements if the special issuance is given. Because that is the entire point of a special issuance, to craft something less than a general medical certificate that puts specific requirements on the airman, and sometimes, for a pilot with night blindness, that airman might not be allowed to fly at night. For a pilot that has perhaps some physical disability and is unable to operate controls in a certain way, There's special issuances that are given that require a cockpit adaptation to allow operation of those controls. The point is the FAA has tremendous experience and capability to craft a special issuance that addresses the particular medical concerns that preclude a general certificate. And that's all we're asking for here, is that the FAA take its time, actually do its consideration. And, frankly, with these other conditions, the the air surgeon proved she's capable at looking at particular medical evidence. We think her cherry-picked sites are wrong and explained them in our brief, but proved capable of looking at the specific pilot. Whereas with Rimron here, there's no look at the specific pilot at all. And that's what this court explained is wrong in Irwin, where it said the
Okay.
FAA is a repeat offender and must, Your Honor. Oh, may I finish the quote?
Wrap up.
Oh, yes. Well, and that was the very last point and that's the standard that this court explained in Irwin, that because the FAA is a repeat offender, they, quote, cannot simply declare its expertise and instead must exercise expertise and demonstrate sufficiently that it has done so. That's not what's happened here. Thank you, Your Honors.
The case is submitted.